Hey.
Hello, everybody. Welcome. Welcome to our next episode of the Justice Revolution. My name is James the Patriot. I'm your host. Today is March the 3rd in the year of our Lord, 2023. I've got my co-hosts, Erica and Justice. Say hello, guys.
Hi.
So we were talking before we went live here, and Erica gave us some disturbing information. I'm sure many of you have been following what has been going on in the world events. Recently, there was a quote-unquote train crash in the great state of Ohio that had some chemicals in there. You guys know the story about that. I'm not going to go into detail. Well, Erica shared some disturbing information. Erica, do you mind sharing that with others?
No, it's good. They decided to contract with a dump site about 20 minutes from my new property, and they've already brought in several truckloads of the garbage. So yeah, there were community meetings that were organized for yesterday, and everyone gathered, and the booing was just crazy to hear about, like, what we don't even have the power to stop it because it's already here. They already dropped it off. And then today we got massive amounts of rain. Amounts of rain. It's flooded. All the fields are totally flooded. It's going to take days for it to soak into the
That is absolutely ridiculous. That is ridiculous because we've already been seeing evidence of what's been going on with this quote-unquote controlled burn, right? Because they said they did a controlled burn of these chemicals. That was not a controlled burn, you guys. In a controlled burn, you control everything. So let me give you an example. Your vehicle, your cars that run on gas, that's a controlled burn. The amount of fuel, it controls the amount of air, and it controls exactly how much carbon dioxide is produced as a result. No, when they just lit a match to this stuff, that was not a controlled burn. So there's some serious problems going on, which is why we do what we do, which is why we're here. This is why we do this show. So Justice, before the show too, she called me about an hour ago, maybe not quite so an hour ago. She has some interesting updates on her situation. We really hope, guys, that this information that we share is not only is it useful, we hope that you guys find value in this. We also hope that you guys can use it. Because the way that we put a stop to this madness is if more of us do this. Remember, the reason why more people don't take the legal action that they should is for two reasons. One, they don't know what they're supposed to do. And two, they have been dumbed down by the Bar Association to think they can't do anything without the assistance of a licensed attorney. And that's just absolutely not true. Yesterday, did I tell you guys that my 16-year-old nephew lives with, 18-year-old nephew. Yeah, he moved in when he was 16, so I'm still in that mind frame. So I told you my 18-year-old nephew lives with us. Well, his dad, before he passed away, he had an investment account of some kind, and there was a significant amount of money in there. I mean, not a huge amount, but for an 18-year-old kid, it's a good size amount of money. Well, his wife, his mom, my nephew's mom, was the named beneficiary of the account. She has since passed away. And so we were trying to figure out, okay, what do we need to do to get this account and these funds into his name? Because he is a living heir. It's his money, right? Mm-hmm. So they kept saying, well, we need a court order. We need a court order. And I'm like, I am scratching my head going, what court order do you need? Because I can't just go to a court and say, hey, judge, sign this. That's not how this works. I wish I could. If it was, then man, life would be super easy. But the come to find out, they just needed a simple guardianship document, which I had when we were assigned as legal guardians when he was 16. So I sent that over to him. But what the purpose of this conversation, of what I'm saying here, is when I was talking on the phone with this guy, he was like, "Well, you're probably going to need to reach out to an attorney," and I about reached through my screen and stuff. I almost had the audacity. Dude, you don't know who you're talking to, do you?
Yeah. You just have to say, okay.
Don't tell me I have to go get an attorney, because that's
everything. Everything I research, that's the first thing they do is they say, well, you should probably consult your attorney first to make sure that these documents are the way that you want. They do the same thing in healthcare. You should probably consult with your doctor to
Oh my
make
gosh.
sure that that's true. Like somebody
Yeah.
get a stamp of authority who
Oh heavens.
Right. It's an establishment thing. It created a situation for all of us to be beholden and dumbed down by, thinking they're our constant answer instead of us taking initiative ourselves.
You know, it's so true, and that's just what was so frustrating. Is like it's just a neat. You know, he didn't know. In his defense, he didn't know. He didn't know he was doing anything wrong. But I'm just like, dude, tell me I need an attorney because I can figure this out on my own. Just tell me what document you need. I'll write it up. I'll walk down to the freaking courthouse. Actually, I'll drive. It's a little too far to walk. And I'll have the judge sign it. So anyway, just funny stuff. I want to give real quick before we get into the show. I want to give a quick shout out to my daughter and to their high school basketball team. I mean, sorry, I'm going off on a tangent, and yes,
Okay.
I'm taking personal time. My daughter goes to a local high school here. So for those of you here in the Utah area, she goes to Fremont High School. Justice, you may have heard of them. I don't know. Their high school girls basketball team has been exceptionally successful. To give you an idea, they have made it to either the state finals or the state semifinals the last 9 years in a row.
Wow.
So they played their semifinal game yesterday. Unfortunately, they lost that game. This other team they played was just, these girls were ridiculous. They were hitting three-pointers that were further than like NBA threes. It was disgusting.
Are they all girls?
Oh, yeah. Yep.
Okay.
Well, they
Just
all
checking.
have tails and long hair, and
I never thought we would have to say something like that, but
so I know. These days you never know anymore, right? So
it's all over the high schools and the colleges. So, you know.
yeah. Well, there was a story that you guys probably saw. It was in Vermont, of all places. Did you see this, Erica?
probably not.
There was a high school girls basketball team that dropped out of the state tournament because they were going up against a team that had a you know what member.
Yes.
So they said, and the statement from the school was, you know, this is just a game, and we want to protect the safety and integrity of this game and the safety of our players. So we're choosing to back out.
They good for them. They needed to.
Yeah,
because if everyone does that, then there's nobody for them to play, and there is no.
Mm-hmm.
That's the thing.
Yep.
And this ridiculousness of the girls being invaded in the locker rooms and stuff.
Oh.
Someone was saying I was forced to change. You're not forced to change in front of anybody in any locker room. Just don't do it. Just say no. Be brave, people. Say no. Teach your children to say no.
We got to stand up. We got to stand up, and we got to say, you know, enough is enough. We're not doing this anymore. You know, I think we've turned over that new leaf. We've turned the page as far as a lot of these other crap that was going on. But you know, I had a good conversation yesterday with my buddy Brandon, the big Sib.
Mm-hmm.
You guys remember him?
Yep.
So he and his cohort, his partner in crime, there's no pun intended for that. They're suing the Chief Justice of the Louisiana Middle District Federal Court because she would not let them go into the courthouse without covering their faces to file a lawsuit.
Yep.
So this could get real interesting real quick, and good on them. So
yes, that happened to me here with this lawsuit. The first time I talked myself in. I told them this is a house of the people, and you can't tell me that I can't do it. And then the second time was like an absolute no. So I said, "Oh well."
Yep. Good for you.
Yep.
You know, I swear the universe must know what we're talking about. I just got a text message. I think I told you guys this. I just did a refinance on my house.
Yes.
I just got a text message 2 minutes ago. A notice of transfer is now on its way. Expect a green envelope in the mail. So you can bet that I'm going to be making sure they do this thing proper and the right way. Because if they don't, they violate laws, guys. And that's what we're here to talk about.
Yep.
Let's talk about these laws they violate, shall we?
Let's
do. So last week, if you guys remember from our show, we talked about unlawful foreclosures. We're going to take a deeper dive into that process, what the process is supposed to look like, and what's supposed to happen. And then we're also going to talk about what to do if you're caught up in the middle of it. Now, regardless, if you're in a state, it doesn't matter which state you're in. It doesn't matter if you're in a state that allows for a non-judicial foreclosure process, like unfortunately Justice and I are in, or if you're in a state, Erica, remind me, does your state allow that, or is it a judicial? You know?
It's a non-judicial.
So you're the same way. The majority of the states, unfortunately, are non-judicial. Somehow they finagled people to believe that that protects your due process rights, which I'm here to tell you it does not. But that's a fight for another day. So
yes, well, I'm sure that could be incorporated into the fight if somebody got into the throes of it, because it does take away your rights. And
yep, it can. So
I don't think we the people agreed to that.
Yep, it can. So what I'm going to do here is I'm going to share my screen real quick. And I got to make sure I cut out some stuff because, again, I am actively working on a new complaint for Justice right now. So, and because we do a lot of our stuff through podcasts, I'm going to make sure I read everything. And if I miss anything, will you two guys hold my feet to the fire?
We'll try. You're a pretty big guy. I don't know.
Okay. So there are a number of different causes of action that we can actually go after someone for when it comes to this. I just wanted to get to the heart of it. Okay. So initially when Justice started having her issues, it was with her current mortgage servicer and the current alleged owner of her mortgage. So you guys have to understand there's actually two things at play here. So when you go get a mortgage loan, you're talking about property, you're talking about real estate. So you can't just go get a loan and have a promissory note and call it good, because that doesn't give whoever gave you that money, that doesn't give them any interest in your property whatsoever. They only have a right to, they can sue you to get their money back. But most people don't have hundreds of thousands of dollars lying around to be able to purchase a home. So the common law and statutory law requires two things. They require a promissory note, which is your agreement to repay the lender. I'm not going to get into anything about this whole promissory note and our signatures and all that stuff. That's not where I'm going with this today. I'm just talking about the process as it happens and as it's been alleged and proven in other cases. Okay. So for those of you,
it's your promise to pay them back.
Exactly. So for those of you who want to have the argument that my signature creates that collateral, this and that, that's not here. We're going to have that discussion. I don't know if we'll ever have that discussion, but that's not where I'm going with this today. I just want to make that very clear. Where I'm going with this today is, let's just assume, and I know the definition of that word before Erica, you put down my throat. I know the definition of assume. So let's just assume for today that there is real money that's been exchanged. You sign an agreement agreeing to pay it back with interest. That's the promissory note. The second document you sign when you close on that loan is a deed of trust. That deed of trust is security interest, guaranteeing whoever is the beneficiary of said deed of trust, which in this case would be whoever lent you the money. It gives them the right to foreclose in the event you don't pay the money back. Does that make sense? Have I lost anybody so far?
I'm with you.
You're with me, Justice? You good?
Yep.
Okay. All right. So here's what happened. This is Justice's situation here, and I just cut out some information here, which is why this looks a little funky. Justice originally took out a mortgage with City Mortgage back in 2005-ish, right around there. There was a number of things that happened in between, but at some point along the line, Nation Star Mortgage, doing business as Mr. Cooper, came in as the servicer.
Now, they were Nation Star.
Yep, but today they're Mr. Cooper. And they changed their name to Mr. Cooper because they got sued so many times as Nation Star Mortgage.
Yes. Yes.
Well, guess what? They're going to get sued again. Okay. So at some point along the line, Nation Star Mortgage, doing business as Mr. Cooper, was the servicer or the alleged servicer of this loan. There was some issues there to catch everybody up. I think we talked about this before. They offered a forbearance to Justice and her husband when he was out of work during 2020.
Yes, he got furloughed.
Yes.
During COVID because of the government shutdown.
Exactly, because
the global shutdown.
Or whatever. Again, it's a discussion for another day.
Yes.
So they offered some forbearance. Well, then at the end of that term, they said, "Okay, now pay us all back right now."
Well, they offered it in the beginning, so it was the only option they gave us. So we called in because I homeschool my kids, so I'm not. We've got one income, so we said, "Are you offering any relief?" Our husband, like the rest of half of the country, has been put out of work due to no fault of our own. Mm-hmm. What are you offering? Yeah. And they said, we'll offer you a forbearance. And typically a forbearance means you're extending the life of the loan. So if they give you 3 months, your loan is now from 12 months to 15 months.
Exactly.
Well, these guys said, we'll give you a forbearance, whatever amount of time it was. But at the end of it, you have to pay it all back in one lump sum. Yeah. And we were like, excuse me, wait a minute. Well, you're under duress, right? You have no income. You're like, okay, we agreed because we had no choice. And we thought, well, it'll buy us some time to figure out what to do.
Yeah.
And you know what happened. Everybody was up and no business, no money. I mean, craziness, right? For the next year. And then when the time came when he was employed again or whatever, we got a bill for $30,000. Give us all this money or else.
Yeah.
And that's when I started saying, well, this sounds like extortion to me. I just feel like I've been strong-armed by, Italian mafiosa down on Canal Street in New York City. Mm-hmm. Wait a minute. This doesn't seem right. So, especially under fair credit and all that stuff, I was like, how is this possibly right? And that's when we asked for proof of the note and the mortgage, and they decided to jump ship, which I found out why today, possibly.
Yeah. So there's a couple of issues right here. when Mr. Cooper offered that forbearance and said, now mind you, they did say up front, you're going to have to pay it all back. That in itself constitutes an impossibility. There's no way on this green earth that anyone who is on forbearance, who's been furloughed or out of work, can know in 8 to 9 months, whatever that time frame was, I'll have $40,000 laying around that I can just throw back at you.
Right. And even if I did, then now you're extorting my savings.
Exactly.
And isn't it supposed to be a negotiable instrument?
No, you're thinking more along the lines of like a credit card. That's a different story. So I'm glad you brought that up, Erica. Did you know something?
No, I never know. I'm just trying to pay attention and trying to dig in the archives of things I've read and come across along the way.
Yeah. So negotiable instruments or revolving lines of credit are a continuous series to contract. Those are non-negotiable instruments. That's a credit card. We're actually going to talk about that next Friday. I'm going to have somebody come on who's been willing to share her case. I still haven't talked to her yet, but I will. And she's going to be willing to share her case. And we'll talk about what to do when and if you get in a situation where they charge off the debt on your credit cards. And now you're being hounded by some debt collector and or shyster liars.
Right.
So good point.
Right.
So
yeah. So the way I looked at it was they're making me an offer.
Yeah.
To contract with them in a different way. Mm-hmm. And I want to make sure that they have legal authority to make me this offer before I contract with them in this way, because the loan got passed off to them. I didn't ask for this company. It got sold and passed and whatever, however they did it, which we can't prove either. James just found out actually. And in my quest to see if they had legal rights to do what they were doing, they cannot prove that they even have legal rights to this loan. So
and we're going to talk about that. You'll see how in this complaint how it's laid out. and how we paint the picture for not only the court, but also a potential jury that would be seeing this if we ever get to that point. So anyway, going back to where we are, Mr. Cooper offered them an impossibility. They felt they had no choice. They took it. Mr. Cooper knew what they were doing. Mm-hmm. They knew that because if they did that, they would send them that bill. They would come back and go, we can't pay this. And then they just turned right around and submitted a claim under the CARES Act for that. There was money in the CARES Act for these people. This is where things get really angering.
Not to mention another insurance payoff.
Exactly. Okay. So that's the second defendant. The other defendant is now who claims to own the promissory note, and that is this defendant here, U.S. Bank Trust National Association, not in its individual capacity, but solely as owner trustee for VRMTG Asset Trust. That was a mouthful. But those people, that is what is known as a real estate mortgage investment corporation, or a REMIC. Mm-hmm. You may have heard that before, right? Have you heard that term before, Erica?
I've never heard it until today.
Okay, you'll see a bit more as I go here in the through this complaint. And then we have New Res LLC doing business as Shell Point Mortgage Servicing. Again, they've been sued who knows how many times, which is why they changed their name. And we have John and Jane Doe's, including all similarly situated as predicate actors. Okay, now I'm going to go up here, right here, because the plaintiffs are private attorney generals and others that are similarly situated. That's important. We do that, and you'll see why. Because this complaint is a complaint for declaratory relief. It is for RESPA, is the Real Estate Settlement Procedures Act. Quiet title, lack of standing to foreclose, slander of title, and claim under authority of 18 U.S.C. 1964, which is the racketeering. That's the civil RICO. Okay? Civil RICO, folks. All right.
It appears so. That's what it felt like.
Yep. So I'm just going to come back up here. Sorry, I got to do something real quick. I thought I was here. There we go. Okay. So then we talk about the parties. I'm not going to go into this because this is, boring stuff. It's the parties. It's who's party to this suit. Okay. Let's get down to the good stuff. Let's talk about the jurisdiction. What have we been hounding into people's heads?
Jurisdiction.
My 13-year-old daughter, she just makes me laugh, because when I take her to school in the morning, we'll pop on, our podcast. I like to listen to what we do. I also like to listen to others. And there was one we're talking about jurisdiction, and she comes home and is complaining to my wife. She's like, all Dad does is listen to these things about jurisdiction. What the heck is jurisdiction anyway?
And you told her I have jurisdiction over you?
That's right. I said, you will do what I tell you to do.
That's a good idea for a show some week, is interview all our kids.
We should, huh? That would be funny. Okay, so we talk about the jurisdiction that the court has. That the court has subject matter jurisdiction over this case under the 28 U.S.C. That's the judicial code. 1331 is a federal question. We have a question that regards federal laws or federal jurisdiction. We talked about the Title 18 U.S.C., which, as I just mentioned, Title 18 is actually the criminal code. Normally, we as individual men and women do not have a private right of action. We do not criminally charge someone. That power and that authority has been delegated to attorney generals. However, Congress allowed under this particular law, Title 18 U.S.C. 1964, which is the Racketeering Influence Corrupt Organizations Act. They allowed civil remedies. They allow people like us to bring forward this in a civil claim. And what happens is the Department of Justice is required to open up an investigation. So this is a great little tool / weapon we have to start bringing criminal charges against people. See, you can do any one of these other causes of action that I mentioned. You could leave RICO out, and they would still be liable. They'd still have to pay money. But guess what? They're going to keep doing this to someone else because to them, it's a calculated risk of doing business.
Right.
And that's what we want to stop, don't we?
Yes.
Don't we want to change behavior?
Absolutely.
Okay.
We want to impose pain and penalty to them as well.
Exactly.
A
Exactly.
deterrent.
Okay, so now the next section that I have here is the notice to the court. So I'm gonna let the court know, hey, Congress, in enacting civil racketeering laws, intended that persons such as the plaintiffs are able to bring this action as private attorney generals. There's a Supreme Court case. There's actually two of them. There's one from 1987 and there's one from 2000.
So we're claiming to be
Private
attorney general.
Correct. Yep.
Okay. All right. I'm holding on.
Okay. We also talk about how we are not members of the Bar Association, thank the Lord above, and are proceeding pro se in this action. Furthermore, the courts have held that is brought by these individuals is not to be held to the same high standards as action brought by licensed liars and shysters and all those other petty blogger shysters. And every other term we could throw at them. Okay. All right. So let's get into the meat and potatoes. So the introduction part is really to give the reader a brief overview of what, oops, I just realized, sorry, Justice, I just realized there was an address there, is to give the reader an overview of what's going on, okay? So I will read the introduction because this is really what hits home on what we're doing here. So starting on line 10, this is an action brought by plaintiffs for declaratory judgment, equitable relief, and for compensatory, special, general, and punitive damages. Plaintiffs, homeowners, dispute the title and ownership of the real property in question. I'm going to skip through that one real quick. There we go. Which is the subject of this action. Plaintiffs are the owners of record of said property as noted by the warranty deed recorded with the county recorder when plaintiffs became the property owners. A true and correct copy is attached hereto as Exhibit A. So Exhibit A is going to be the warranty deed that Justice and her husband signed when they purchased property. Okay, good so far?
Yeah.
The originating mortgage lender and others alleged to have ownership of plaintiff's mortgage note and or deed of trust have unlawfully sold, assigned, and or transferred their ownership and security interest in the promissory note and deed of trust related to the property, and thus do not have lawful ownership or a security interest in the plaintiff's property, which is described in detail herein. For these reasons, the court should quiet title to the property in the plaintiff's name. Additionally, plaintiffs bring causes of action against all defendants for declaratory relief, civil RICO, and violations of RESPA. We talked about what that was already. Upon the facts and circumstances surrounding plaintiff's original loan transaction and subsequent securitization. Defendants' violations of these laws are additional reasons this court should quiet title in plaintiff's property and award damages, rescission, declaratory judgment, and other relief as requested below. All right. So now, in order to bring a RICO claim, we have to allege that they do certain things. This next section talks just about that. The defendants, City Mortgage, Mr. Cooper, Shell Point, and BRMTV, whoops, that's a typo, I need to change that, BRMTG, are associations, in fact, affecting interstate commerce, have, whoops, I put that in there. See, I always find my little typos when I read through this again. Have manufactured evidence of indebtedness and used false evidence of indebtedness to extort property from plaintiffs. I need to get rid of that comma and just put and. There we go. Sorry.
So here's a quick statement. Let me just pop it up, James, because sometimes we get past this point. So.
A QWR to validate the debt. So have you done a QWR to validate the debt? There has to be note and assignment together. Otherwise, the entire mortgage is void. I went through this exact thing in 2008 in Rhode Island Federal Court. Megan, I'm glad you asked. I'm getting there. I'm assuming a QWR, is that a quo warranto, or what exactly do you mean by QWR? Can you expound on that?
She's talking about how it separates, right, with MERS and so forth?
Mm-hmm. Yeah. Yep. We're going to get to that too, because it's not just MERS. Pretty much every single one is separated. because it would be impossible for. So you have to look at it this way, right? Let's just go back and keep this simple. Qualified written request. Okay, thank you. Yes, we have. Oh, and thanks, C to AZ.
That's the debt validation request, right?
Yeah.
The
Yes,
original
10 times, Megan.
Oh my gosh.
About 10 times.
I can't tell you how many times she has done this. So,
which is what led them to sending me, rather than giving me the information we were asking for, they sent me a photocopy, in which my response was, well, then photocopies of my license and passports should be just as valid. We need the documents, and that's exactly what led them to sending a foreclosure attorney after me, because that's what we were asking for after the extortion attempt.
Well, not only that, Justice, all they sent you was a photocopy of a document you already had access to. It was the original deed of trust, which anybody can access because that's a public document,
right?
And that's recorded at the county recorder. So, so Megan, that's a great question. We're gonna get to that. Okay. But going back to what I was saying is the reason why these loans are separated from their deeds is because it's not profitable for investors to invest in only one loan. There's not enough interest made off of that to be a profitable venture. So, for example, if I were to lend $1 million to Justice and Erica, and $500,000 to Justice and $500,000 to Erica, and I wanted to turn around and sell those loans to someone else who wants to pool that together with, say, another 5 or 6 loans, where now they can actually get some decent returns on investment, they can't do that as long as the promissory note and the deed of trust are together. They have to separate them.
Really?
Now, correct. James, I had heard once, I came across it at some point in all of my studying, that we were intended to be the original benefits of that endeavor, that once the interest was made through that process of going into trust and all the extra money that's made after that, that we are supposed to be part of the shareholders as those who are applying for the mortgage, so that because think of all the extra money they make in that endeavor. Wouldn't that be a fantastic system? Then if it benefited us to the trustees are supposed to work on our behalf. That's kind of what I thought. But then we were kind of eliminated from that, and then they became the beneficiaries, and they get the reward from doing all of their business that they don't tell us about.
Of course.
Yeah, it really is heartbreaking, and it's disgusting when you see what they do and how this process goes out. You're going to see how, when I go through this introduction, how we help to kind of tie all of this back together and how it makes a little more sense.
Okay.
So going further here, I talked about how the defendants manufactured evidence of indebtedness and used false evidence of indebtedness to extort property from plaintiffs. There you go, Justice. Agents whose acts clearly identify them as predicate actors, acting for and in concert with the defendants, knew and understood that the alleged claims against the plaintiffs, which deprived them of their property worth in excess of $800,000, were based on manufactured evidence of indebtedness. The taking of plaintiff's property based on false evidence of indebtedness was accomplished by 2 or more of the predicate actors working for or in concert with the defendants. The pattern of defendants and manufacturing evidence of indebtedness to take property away from persons who have no lawfully enforceable obligation to defendants will likely continue unless abated. That right there, guys, that is your civil RICO in a nutshell. That's what that is.
Is it attempted taking? Because they didn't take anything.
No. Yes, they did. You paid them money, didn't you?
Oh, well, yeah. That property. I'm thinking of real estate. Sorry.
Yeah, no.
Money.
Property is anything that you own is your property.
I understand, but we're talking about the property, so that's where my head was.
Yeah, no, I get it. Okay, so now we're going to get into some history. From 1998 until the financial crash of 2008-2009, more than 60 million home loans were sold by originating lender banks to investment banks to be securitized in a complex series of billions of transactions. Plaintiff's home loan was one of the 60 million notes that was securitized. Securitization is the process whereby mortgage loans are turned into securities or bonds and sold to investors by Wall Street and other firms. The purpose is to provide a large supply of money to lenders for originating loans and to provide investments to bondholders which are expected to be relatively safe. The procedure for selling of the loans was to create a situation where to buy certain, where, I think that's supposed to be whereby. That is. Whereby certain tax laws known as the Real Estate Mortgage Investment Conduit, that's what that actually was, hereinafter a REMIC Act, were observed, and whereby the issuing entities and the lenders would be protected from either entity going into bankruptcy. In order to achieve the desired bankruptcy remoteness, numerous true sales of the loans had to occur, in which loans were sold and transferred to the different parties of the securitization. So there's a process. It's not just goes from your original bank to whoever owns the loan now. There's a process this goes through. You guys will see what I'm talking about. A true sale of the loan would be a circumstance whereby one party, gosh, I got a bunch of typos in here, whereby one party owned the note and then sold it to another party. An offer would be made, accepted, and the deeds of trust assigned to the buyers of the note, with an assignment made every step of the way. And furthermore, each note would be endorsed to the next party by the previous assignee of record. Okay, pretty simple, right? If I give a loan to Erica and Justice wants to buy that loan, I have to write up a contract, sell it to Justice. I have to sign it. Justice has to sign it. Pretty simple stuff. That's how it works. Unfortunately, because there are so many home loans that go through this process, they never do this. Even today, even after the financial crash of 2008, 2009, they're still doing this. So each REMIC trust or REMIC trust created by the investment banks, usually under New York law, would be funded with thousands to tens of thousands of mortgage notes. In order to maintain their bankruptcy protected status, REMICs had to have closing dates by which every mortgage note that was sold to the REMIC had to be owned by the REMIC. Once the REMIC closed, it could accept no more mortgage notes under the terms of the REMIC law, and it would begin selling securities backed by payments from homeowners on the notes it owned. Again, another little typo. How a particular mortgage loan ended up being transferred to a REMIC in the securitization process is governed by a contract known as a pooling and servicing agreement, otherwise known as a PSA. You guys ever heard of that term before?
Yeah.
Okay. The PSA is a trust agreement required to be filed under penalty of perjury with the United States Securities and Exchange Commission, otherwise known as the SEC, and which, along with another document, the mortgage loan purchase agreement, is the operative securitization document created by the finance and securitization industry to memorialize securitization transactions.
And what an easy read it is, let me tell you.
Ooh,
It's like
yeah.
1,000 pages. Good luck.
So James, wrap that up in a nutshell for the newbies, please.
Okay. Basically what it is there's two documents. Okay. There's a document that governs the process of how your mortgage gets sold to an investment bank. Okay. And the second is the process by which the document that secures your property goes along with that. All right. We talked about earlier, there's two documents. There's your mortgage, promissory note, and then there is the deed of trust, which grants whoever owns the mortgage the right to foreclose in the event of default. Okay. So moving on, when the plaintiffs in this case closed on their property, their original lender, Defendant City Mortgage, Inc., signed a pooling service agreement, or a PSA, that governed the plaintiff's particular mortgage note. The PSA agreement, as described in more detail below, detailed the closing date by which the homeowner's loan must be sold to the investment corporation, and described exactly how the homeowner's note is to find its way from the original lender to that trust. All right. You with
Okay.
me so far?
Yes.
It gets kind of crazy here, but I want to give everybody the big picture. And this
Yeah.
is what we do when we do these complaints. We give that big picture.
I might fall off the fence at this point.
I have a little graphic here.
Flip chart. Good. I'm a visual. I like
Yeah.
that.
Yeah, we have a little graphic that might help you out here. Okay. So a typical pooling service agreement, or PSA, calls for a homeowner's note to be transferred at least 4 different times to key parties before it comes into possession of the investment conduit trustee. This is crazy, you guys.
So insane.
So I've got a chart here that details how that is. And so for those of you who are listening, I'm going to talk about this. So the first step in the chart is we have the originator, or your original lender. This is who originates the loan with the borrower. They usually retain the servicing rights to the loan. So you'll make your first or second payment to them usually. Then what happens? Well, what's supposed to happen is a sponsor is supposed to buy the closed loan from the originator, and they might add loans from its own. So again, a sponsor can be another bank. It can be just someone who does more like investment guys who will just buy up mortgages and then sell them on down the line.
So do you have the names of these institutions for this project, for this?
Nope,
Okay.
I do not, and I'm not going to, because we don't have to. All we have to do is allege it. It's not on us to prove who exactly was supposed to be what.
Okay.
That's not our job. Okay. From there, once the sponsor gets again, this is the process that the pooling service agreement says must happen. So you think of it this way: A, B, C, D. You got to go from A to B, B to C, who C is now the depositor. They supposedly buy loans in what's called a true sale, and they immediately convey to the mortgage investment conduit trustee, who is number D, who's letter D. They hold legal ownership and has loans serviced for the benefit of the security holders. Okay, so when you guys make your mortgage payments to, Shell Point or Mr. Cooper or whoever it is that's servicing your loan is now in this REMIC trustee. However, in order for it to be valid, in order for the trustee here down at the REMIC trustee, in order for them to be able to foreclose on you, they must prove and show proper assignment from A to B, B to C, C to D. They must also prove and show that they have the original paperwork from A to B, B to C, C to D. Does that make sense?
Mm-hmm.
The original. So the documents you signed at closing, those must be in possession, in physical possession of this real estate investment trust. Any questions on that so far?
Yeah, I have a question. I don't recall any of this information being disclosed to me at the closing.
Yeah, because it's not.
Mm-mm.
No, it's not.
Is this an internal process that doesn't include us at all?
Yes, it's not supposed to include you. So under the common law for contracts. Now again, you can argue that there wasn't a meeting of the minds because no one explained to you that, oh, hey, we're going to sell this and we're going to do this and this and this. I mean, you can make that argument. I haven't seen a lot of success with it, but it doesn't mean you couldn't make the argument. But under the common law, as long as there's a provision in the contract that states, hey, we retain the right to assign our rights to this or sell this. If you agree to that, which, most of these mortgage loans, these mortgage contracts, these promissory notes, they all contain those provisions. So,
and they tell you really quickly, like the pharmaceutical ads.
Yep.
They run it by you so fast.
And it's like, so you hear this great ad.
Tell you.
Yeah, that you hear this great ad, and then at the very end you hear, and no.
Mm-hmm.
What now?
Yep. This will help you sleep, but it may cause heart attack, stroke, death, blah, blah, blah.
Yeah. You may wake up dead and you're like, wait a minute, how did this happen?
Yeah.
So that this is what happens behind the scenes. There are people, organizations that will do a forensic audit of your mortgage. This is what they find. They find this information. And they're doing deep dives through, because all of these documents have to be filed with, like I said, the SEC, the Securities and Exchange Commission. They find all of those documents there. They find the process, and they find, well, wait a minute, this doesn't comply with not only contract law, but the terms of the agreement. Okay, so let's get on to the next process, the next part, excuse me. As a part of the process, the banks almost universally separate the mortgage note from the deed of trust. Under the common law, the owner of the note has the right to the payments on the note, and the owner of the deed of trust has the right to foreclose on the homeowner if the homeowner defaults on the note. We talked about this. Traditionally, before investment banks began securitizing mortgage notes, the holder of the note would universally hold the deed of trust. They were one and the same. Gone are the days when it used to be you'd go to the bank, they'd give you a loan, and you'd make your payments to the bank. Those days are gone. I mean, it's different. Like if you go get a car loan, you get a car loan from, like, let's say, your local bank or credit union, you make your payments to them. So
this might be helpful. Let me pop this up for everybody.
Okay.
Megan, would you share the information of the company that you used?
Oh yeah, it's any title company. Title
Okay.
companies will do that. So you can do a deep dive with a title company.
Okay.
So that's good stuff to know. Thanks, Megan. So going back to
trustworthy sources are worth sharing,
Well, I mean, any title company will. So a title company does a deep dive on the entire process of your property. So you can go to your county recorder and you can find documents that were recorded against the property, but you might not find other stuff that entails what's going on with your property. However, a title search will do that. But it's like Megan says, it's a couple $100. Sometimes it might be more, sometimes it might be less, depending on where you are.
And the securitization audit, which is also something recommended, that's what will show you the process from A to D, correct?
It's supposed to. Yep. It'll name everybody from A to D who was involved, when they were involved. The whole 9 yards. Okay. So traditionally, before investment banks began securitizing mortgage notes, the holder of the note would universally hold the deed of trust. This made sense because they were the party that had the right, another typo, with the right to collect payments on the note and would want to be able to foreclose using the deed of trust if the homeowner defaulted. I mean, this all makes sense. However, in order to streamline this process, the investment banks created an entity called Mortgage Electronic Registration Systems, otherwise known as MERS. You guys have heard of them before, right?
Mm-hmm.
Yeah, they're evil.
So explain that for folks that are just entering this process real quick, what MERS is and why it is, if you don't mind.
So all it is an electronic system whereby these mortgages are securitized and processed. That's all it is.
As opposed to packing up your stuff and sending it securely, they can get the process done much quicker.
Done electronically. I mean,
Right.
everything's faster electronically, right?
Right.
If I can send you an email, boom, it's done. But if I have to put it in the snail mail, or if I have to send it with a courier where you sign for it and I can show proof of delivery, that's going to take longer.
Right.
And that's a big process.
But that doesn't go along with all the paperwork, and it's never supposed to be separated from the note. So this is where a lot of fraud has been committed to many people nationwide.
Oh my goodness. You have no idea. And then, like I said, it's still going on today. Okay. So again, MERS is an investment, it's an organization that was created by the investment banks where they would transfer the deeds of trust to the MERS, thereby separating the mortgage note from the deed. MERS would hold the deed of trust for whoever claimed to be the owner of the homeowner's mortgage note. So plaintiffs in this complaint allege that defendants and each of them cannot show proper receipt, possession, transfer, negotiations, assignment, and ownership of plaintiff's original promissory note and their original deed of trust, resulting in imperfect security interest and claims. Okay? Plaintiffs further allege that defendants and each of them cannot establish proper possession, establish possession and proper transfer and or endorsement of the promissory note and proper assignment of the deed of trust herein. Therefore, none of the defendants have perfected any claim of title or security interest in the property Defendants and each of them do not have the ability to establish that the mortgages that secure the indebtedness or note were legally or properly acquired.
Can I interrupt real quick?
Yep, go ahead.
I just want to let people know this is not a unique situation to me.
Nope.
What he just went through here, probably 90% of the loans out there, this applies to.
And they're still doing it today. So I can, again, I mentioned earlier in the broadcast, I just recently refinanced my house. Guess what I'm going to do in about 6 months? I'm going to do a securitization audit. I'm going to make sure they're doing it right. Because if they're not doing it right, then again, you guys have to know how this works, right? You're not cheating anyone. I want to make this very clear. You are not going to get a loan with the expectation that you're just not going to pay them. Okay? That's not how this works. You agreed to pay, and you are going to stand on that. You're agreeing to fulfill your part of the deal. But if they commit fraud anywhere along that line, why are you still required to pay? Does that make any sense to anyone?
Right. They're robbing you. They're playing games to steal money from people.
Here's something you guys need to know and understand. We go back. We have the two documents that go with a mortgage, the promissory note and the deed of trust. And we have that process, A to B, B to C, D to C, C to D.
C to D.
Each step of the line, there's supposed to be an offer, a contract, consideration, money, and an agreement. Bought and sold, bought and sold, bought and sold. But what happens when they separate those two documents and the promissory note just stays behind and the deed of trust just keeps going bought and sold, bought and sold, bought and sold? Well, guess what happens? The promissory note has been paid. So under the terms of the agreement, it's been fulfilled. So who owes who any money?
So they're double, triple, quadruple dipping.
Exactly.
So then when they come after you, even if it is a judicial state for foreclosure, who has claim for harm, right? Come forward, right?
That's the conundrum.
Who can claim that they're the real party in interest?
That's
who's damaged? Right?
Yeah, who's damaged?
Who's damaged by this? So this is what I'm trying to get at, you guys, is as long as they do what they're supposed to do, as long as they take the promissory note and the deed of trust and they transfer them both, the original documents, sign and endorse and sign, and they show a receipt of that, you're good to go. They don't do it. They never do. Like I just did a recent title search, just what I could do sitting here in my home office online of Justice's property. I could find the assignments of the deed of trust, but there was no other supporting documentation. Nothing. So that's not proof of anything. I can't see where there was ever an agreement between the two parties to purchase this. And where's the promissory note? Because when you look, the original deed of trust and the promissory note are actually encapsulated into one document. But then somehow, magically, it gets separated. How does that happen? I don't understand that. That doesn't make any sense to me at all. Okay. Now I wanted to go back into my Rico claims. Oh, geez, Megan, please no. She says, I was told by my lawyer, he may rip. I mean, I think she means he may rest in peace.
Yeah.
They have made 7 to 8 times the amount on the loan prior to initiating foreclosure, and they make money foreclosing. You're not wrong. It's true. You're not wrong. You're not wrong. It is true. So let me go back to where I was. I wanted to harp back again on Rico claims. Because again, is this not criminal? That's my question. Going back to your question, going back to what Megan just stated. Erica or Justice, is that criminal?
I feel like it is. I feel like they could make remedy by just telling us about it and letting us be one of the shareholders. Because even if we just made one time, as a shareholder, then it's paid off. I don't know. It just seems like.
Yes, but that's why they don't tell you, because they want to make it 7, 8 times. They've got a game. This is a long con. A mortgage is a long con, basically.
Isn't that called fraud in the concealment?
Yes.
Isn't that what that is? Where you're concealing what's going on with what's really happening, and you're inducing another party to make payments based on that concealment? Isn't that fraud in concealment?
I think the argument
and without proof, without validated proof. This all started because of an extortion attempt, and no one can validate proof of ownership. Nobody.
Yeah.
So for you folks that are brand new or feeling like this is just starting for you, you've got to ask for the proof of the notes with, as James says, with wet signature, which means your original document. The original document is not a photocopy that they will mail you, because that's what they will do. So in that case, again, I'm going to say it over and over because this is the analogy that people can reason with, is a photocopy of your license would be valid, of your birth certificate would be valid, of your passport would be valid, and all of these are not valid. Photocopies are not valid.
No, because they can be manipulated. So here, there's also an alternative to that. If they don't want to send you the original document, hey, I get that. Why don't you go ahead and send me a certified copy by someone who signed under the penalty of perjury that this is the original document?
Right.
They'll never do that either.
Right. With an affidavit, accompanying affidavit, and notarized.
Yep. Yep. So to wrap this up here, because we're coming up on an hour, I wanted to hit Rico again because, like I mentioned before, this is criminal what they're doing. Plaintiffs in this complaint testified to injury to property by reason of acts which violate Section 4 of the Clayton Act, which is the precursor to the Rico. Plaintiffs have articulated violations of racketeering laws, testified that the violations injured property, warranting treble damages. In naming the defendants, plaintiffs have established that an enterprise exists which undeniably affects interstate commerce. Clearly it does, because they're doing this all over the United States. Plaintiffs have standing to sue under Rico, as plaintiffs have shown violations of Rico, injury to property, and causation of the injury by the violations. Plaintiffs have perfected a Rico claim by showing the existence of a Rico enterprise, showing a pattern of racketeering activity, fraud, shown nexus between the defendants and the pattern of frauds, and shown resulting injury to property. Additionally, plaintiffs have demonstrated that plaintiffs have sustained injuries as proximate result of the pattern of frauds by the defendants. As a result, plaintiffs allege that an actual controversy has arisen and now exists between the plaintiffs and defendants, and each of them. Plaintiff desires a judicial determination and declaration of their rights with regard to the property and the corresponding promissory note and deed of trust. Plaintiffs also seek redress from defendants identified herein for damages, for other injunctive relief, and for cancellation of written instruments based upon A, an invalid and unperfected security interest in plaintiff's home, hereinafter described, B, void true sales, violating Utah and federal law and express terms of the pooling and servicing agreement governing the securitization of plaintiff's mortgage, C, an incomplete and ineffectual perfection of a security interest in plaintiff's home, and D, manufactured evidence of indebtedness and false evidence of indebtedness used to extort property from plaintiffs. Okay?
Okay.
Boom. That was a lot. So, any questions on any of that? Is there any questions in the chat that
yeah.
So, what about the approach of using the Fair Lending Act to question bogus fees to invalidate the entire note that Randy talks of? So, that's not a bad approach. However, I'm not a numbers guru like Randy is, and he can put together these spreadsheets to go all over this stuff here. That's another approach. I'm not saying it's wrong. It's just one that I'm not well versed in. I'm a little odd, and then I want to take the quote unquote path of least resistance. That's not necessarily what I'm meaning. I want to find my winning argument, and I'm going to stick to that winning argument. That's the Justice Scalia way. So that's the Antonin Scalia way.
And Richard Cornforth says the same thing.
Exactly. Richard says the same thing. You know, he's like, hey, you don't need to get caught up in the weeds of things. And I'm not saying that process that Randy advocates for is the weeds. I'm not. It's just, it requires a detailed documentation and going through things and alleging this and alleging that. And it's just like, oh man, it's going to make your head spin. I just wanted to get to exactly the bottom of what we're getting at. So,
and it all started with just asking for proof of ownership, and they can't provide that. And we did file an SEC complaint, Megan.
Yeah.
And
So
they
Megan
never,
asked the
they
question.
never responded, actually.
No. So Megan asked the question, isn't this also SEC fraud, or is that covered by Rico? Yeah, it is securities and exchange fraud. It really is. It's securities fraud.
Absolutely.
But we're covering that under Rico. So because you have a cause of action under civil Rico for securities fraud. So I talk more about in that complaint later on about how the defendants mailed documentation, they did harassing phone calls, they did all of that stuff in an attempt to extort money under the guise of saying, hey, you owe us this debt. I was like, well, I don't owe you anything because you can't prove that I do.
I'm curious to hear, Megan, real quickly, if you can type it in there, what your outcome was. You said you'd gone through this. Share us what your outcome was. And if it's a teach-worthy moment, maybe we'll pull you in. We wanted to do one with guests also that have had success in unorthodox ways, so to speak.
Mm-hmm. Jen brings that point up. She says, great strategy. Take the strongest point and go with that. Don't muddy the waters with too many things. It works. I just had success yesterday using that strategy. Jen, reach out to us on Telegram and let us know. We would love to have you on the show.
Yep. We want to definitely share success cases. The more we all converge together and share how to do this as we learn outside the secrets that they keep, the quicker we can overtake their fraud.
Yep. So, you guys, that's what I had to share today. I am not done with that complaint. But when I am, I will share it. Obviously, I'll take Justice's information off of there, so it's not her personal information. But I will share that complaint in its entirety in our Telegram group. So, well, that's great to hear. So Megan says she won her house back, but she still has to deal with the different servicers. Still illegal, but my situation is complicated. Well, hey, Megan, hopefully that this complaint will give you that ammunition you need. We're here to help. We'll do what we can.
Yeah, and we'd like to hear some more details. Also, if you're not in the Telegram, I'll pop it up here. I usually run all these things, so let me run them real quick, because the first thing is we're not giving legal advice.
Oh, yeah. Please.
So there's our disclaimer. We're not giving legal advice. We're sharing ideas of things that work that are well within the system that the United States has created for us, we the people.
Yeah.
And have hidden because the British Accreditation Registry decided they wanted to make it a business for themselves.
Mm-hmm.
And many judges are in coercion with them, right? So that's another thing too, is I don't know if we want to add it, but we want to talk about it, that the judges profit off of this as well.
Yeah, they do.
And that's many people have issues, and they're basically wrongful decisions are made because the judges will make money based on the decisions. So we might want to put an FYI in that lawsuit, letting the judge who's reading it know that we're on to that as well.
Yeah, there's a lot of things, again, don't think that just because you file a lawsuit that it's just going to be peaches and roses from there on in. It's not. I mean, there are these judges that I'm dealing with that are just dumber than a box of rocks. I mean, there's no better way to describe that. It's still a fight. Eventually we will get to an adult in the room, as long as we have that winning argument, and as long as we stick to that and we don't let these liars deviate us from that course, we're going to be just fine.
And just understanding that just because someone is a lawyer or a police officer or a teacher, some people do their jobs better than others. Some people love their jobs and love what they do, and some people fight for justice, and others are corrupt and take handouts. So there's always that. That's
Yep. So, all right, you guys, with that, we're going to wrap the show. Thank you guys so much. I have a trouble when it comes to Friday. I'm like, it's so, and Erica's always laughing at me. Thank you.
Just accept you and love you as you are.
Oh, that's funny. That's what my mom said.
Stutter and mess it all up. It just wouldn't be the same. Don't ever stop doing that.
See, my mommy told me I was special too.
Yes. So. Good thing for mommies.
Anyway, thank you guys. Enjoy your weekend. I hope this information was good and you guys can use this. Like I said, when I get done with that lawsuit here in the next few days, I hope I'll post it up in our Telegram chat. You guys are welcome to plagiarize it, use it, do what you can. But again, we're not going to see this change we're not going to see a change in behavior until more people step up and say enough is enough. So
right. And if you need beginning on the YouTube channel, there is how to write a lawsuit. So if you want to get started and grab a template and whatever, again, put it in the Telegram chat, ask for advice, ask for a look-see, and just get started. Take one step, right?
Yep. And to everybody who has subscribed to our channels, YouTube, Cloud Hub, Facebook, everywhere we are, thank you so much. Keep those keep subscribing, keep getting the word out. We just want to get this information out to as many people as we can. Again, you guys, YouTube know this. I've had people ask for my help, and I do what I can. And I've had people offer to pay, and I'm like, nope, I won't do it. That's just not how this works. So it doesn't. I feel that this information is too valuable to charge money for, if that makes sense. It's priceless information that we, the people, need to know. And this is information we should have been taught years ago when we were kids, but it was hidden from us on purpose, and we're seeing why.
So just speaking of that, because James is so stubborn, I did create a buy me a coffee, because you have to be in honor of other people too. And I know James just wants to help so badly, but some people want to contribute and they don't know how, and they would love to throw in $5, $10, whatever, and contribute. So we decided we would do a buy me a coffee. And if nothing else, if someone needs financial help, then we've got some funds in there to help people. But I don't want to shut people down either, but James doesn't know that, so now he knows.
Well, hey, and two, I believe we also have an Etsy store.
Yes, that's brand new.
Justice just set up an Etsy store. I guess you guys can go and purchase the Justice Revolution T-shirts and stuff. I mean, that's exciting. I've never had my own store before. Very cool.
Yeah, someone said that's a cool logo. You should put it on a T-shirt. I'm like,
it really is. I love it. And bless you guys. Everything you're seeing, all of the marketing stuff, everything. This is all Justice, and so God bless her for doing this, for putting this together. Yes, I know. For those of you who are listening, they're giving the little heart signal right here.
Well, we all have our own strengths, and when we help one another, good things happen, right? So
that's right. That's right. All right, you guys. With that, God bless you all. Have a great weekend. Again, our next episode, next Friday, we are going to be talking about what to do with those pesky debt collectors.
Hold on, before we go, James, we got a quick, what is this here? Oh, okay. Yes, in the YouTube, you must be talking about the YouTube. All right, I'll figure that out. Mystic Rose, sure.
Oh, for the transcript?
Yeah.
Okay. Yeah, so tune in for next week. We're going to talk about those pesky debt collectors and how to stick it to them. Until then, you guys, take care. God bless you all.
Bye.